we are now going to discuss the preamble and its features and the cases related to that, so that we can enter into union and its territories. Okay, fine. So preamble. There are some static data which is important for this understanding. In nationwide protests against the Citizenship Amendment Act, as of now, which is gained the importance at the national level, many have upheld saying that preamble as reflective of the essence of the Constitution of India in the context of secularism. So keeping that current affair in the point of view, we are now going to discuss about preamble of Indian Constitution. We can say that preamble of Indian Constitution is a brief explanatory statement that sets off the guidelines, the directions which could guide the people of the nation and to represent the principles of the Constitution and to indicate the source from which the document derives its authority and meaning. And in this context, the preamble of Indian Constitution is the hopes and aspirations of the people which was described by the framers of our Constitution. The preamble can be referred as the highlights of the entire Constitution as well. It was adopted on 26th November 1949. 26th November 1949 is the day of adoption by the Constitution Assembly and came into effect from 26th January 1950, where we used to celebrate Republic Day in India, enforcement of Constitution, the day of enforcement of our Indian Constitution. So in that context, let us understand the resolution and discussion here, as we have discussed in the previous chapter as well. It was completely based on the objectives resolution which was introduced on 13th December 1946 by our J.L. Nehru in the Constitution Assembly, and it was adopted. Objectives resolution was adopted by 22nd January 1947 by the Constitution Assembly. And on October 17th, 1949, the Constitution Assembly was presided by Rajendra Prasad, who took up the preamble for the discussion. And as a part of that, we can clearly say that the preamble can be seen as the heart and soul of Indian Constitution, which was a statement given by B.R. Ambedkar. And now, as we discussed about the preamble, important features like SSSR means sovereign, socialist, secular, right, democratic and republic, liberty, equality, fraternity, unity and integrity. Okay, as we discussed that as a part of the previous chapter, the features of Indian Constitution. Today we need to understand in that current affair linked part, there are some important cases with respect to this, and one of that case is your Beruberi case of 1960. Beruberi case of 1960. There are two questions with respect to this case. One is preamble a part of Indian Constitution? There is another one, another question, another argument. Is Parliament of India having power to amend? Third part means fundamental rights of Indian Constitution. These are the two most important questions which were raised as a part of your Beruberi case 1960, where Supreme Court held that view that preamble cannot be the part of Indian constitution. No is the answer. No, preamble is not the part of Indian constitution. Okay. And for the second question here, yes, the second question here, even for this question, the Supreme Court held saying that Parliament is not having any power to amend the third part of Indian Constitution. So as we are discussing about the preamble and the related cases as a part of this session, you are now going to concentrate on only this. What is that? Is preamble a part of Indian Constitution? And the Supreme Court judgment here is no is the answer. And the second important case, which is one of the most historical judgments of the Supreme Court, where for the first time a 13-bench constitutional bench was formed in the Supreme Court, and that case is nothing but your Keshwananda Bharati case. Keshwananda Bharati. Keshwananda Bharati case, 1973, Keshwananda Bharati case can be observed. So in this Keshwananda Bharati case 1973, Supreme Court held that saying a comprehensive verdict, a comprehensive judgment, saying that preamble is a part of Indian Constitution. It is not just a part of Indian Constitution, but Supreme Court clearly mentioned that preamble is an integral part of Indian Constitution, from where the philosophical foundations could be observed. So Keshwananda Bharati case, this is the judgment. For the examination you need to remember. It also clearly stated Parliament is having the power to amend the Constitution, and as preamble is a part of Indian Constitution, even the same judgment is clearly stating that the preamble can also amended, and it can be seen as the power of the Parliament. And not only that, in this so-called historical judgment, for the first time the Supreme Court used a word called basic structure. Basic structure. So whenever we come across the word basic structure, what is that case related? In the sense, your Keshwananda Bharati's case, clearly saying, yes, Parliament is having the power to amend any part of Indian Constitution, provided it should abide to the basic structure of the Indian Constitution. But for the first time, as there is no word mentioned, as there is no definition placed in the Indian Constitution, no one knows about basic structure. From that it is very clear the basic structure definition, significance, importance, or any matter with respect to that basic structure is the only power of the court to decide. And as a part of that, Supreme Court clearly stated or defined basic structure, and that basic structure comprises of some characteristics which are nothing but the same characteristic features of Indian Constitution which we discussed previously in the previous session. Okay, so this is the part which you need to understand. And you know what? Supreme Court also clearly stated, if at all required, if the Parliament want to amend the Indian Constitution, it should amend according to 368 article, which mentions about special majority. About special majority. So 2/3 special majority is required for the Parliament of India by both the houses to amend the Constitution. Even for the preamble also the same. And hence the question here, till date, how many times the preamble got amended? And the answer is, it got amended only once till date. And 42nd Constitutional Amendment Act 1976, through this three important words were incorporated in the preamble. One is your socialist, second is your secular, and third is your unity and integrity. Not only that, according to the same 42nd Constitutional Amendment Act, even fundamental duties where new part 4A was got created, and under this a new article 51A also got inserted. Okay, so this is what the point is. So this is what the point or the most important concept with respective to the cases of the preamble related. Okay, so these are the most important points to remember. And now we are entering into the concept of union and its territories, which falls under part 1, schedule 1 of Indian Constitution. So part 1, schedule 1 of Indian Constitution under articles 1 to 4, talking about the union and its territories. These are the compilations of the laws of India as a country and the union of states, and it is made it clear that these laws with respect to this were established to hold of our constitution. And in that part we are now going to discuss about union and its territories under articles 1, 2, 3, 4 which falls under part 1, schedule 1 of Indian Constitution. So here comes article 1. Article 1 is talking about the name and the territory of the union. It is talking about what? The name and the territory of the union. So what it is saying, India, that is Bharat, shall be the union of states, and hence the current affair, a debatable affair, that there was a small argument which was filed in Supreme Court demanding to change the name of the country from India to Bharat. And it is not a new concept. Right from 1970s, if I am not wrong, it started. But recently under UP government, under Yogi Adityanath government, it was again filed, petition was filed in the Supreme Court to look into that issue for the name change of our country from India to Bharat. And as a part of that, as a current affair and contemporary affair, this article 1 has its own significance. Only according to article 1, the Supreme Court many times said, and even in the recent judgment given by Supreme Court clearly stated that this so-called India, that is Bharat, shall be the union of states, was clearly mentioned in the parliament, in the constitution. And hence you need to understand, it is the matter of choice for the Indian citizens to call with either of these two names. No need to rename or change the name of our country from India to Bharat is necessary. It is not necessary. I hope I am clear. So article 1 gained its significance. And more importantly, the territory of India comprises of the territories of the states. The territory of India also comprises of the union territories which were specially, significantly mentioned in your first schedule. And the same union, the territory of India comprises of such other territories which can be acquired by our country. So this is what exactly your Article 1 is talking about. So simply saying for your examination as an application part, Article 1 is talking about the names, the boundaries, the shell, continental shell, your exclusive economic zone, your SEZ, special economic zone, okay, and the names of those, everything, let me say for your understanding in a better way, the physical representation of the boundaries of India along with the names were clearly mentioned in your Article 1. I hope I am clear. And now we are entering into Article 2. Article 2. Article 2. Okay. Article 2. Parliament may by law admit into the Union either to establish a new state on such terms and conditions if it thinks fit. Okay. In other words, we can say it is the power of the Parliament with simple majority. I repeat, it is the power of the Parliament with simple majority either to annex a region into the Indian Union, and same power of the Parliament with simple majority to give the status of a state, to represent a small political unit as a state, if at all Parliament thinks that it is best fit to that. Not only that, it is also saying, Article 2, that it is the power of the Parliament with the same simple majority to leave away, to give away a small territory or the maximum, to change the boundaries, right? So let me say in other words, if it want to annex a region to become the part of Indian Union, power of the Parliament, right? The same power of the Parliament is also saying that you can leave a particular portion or a territory of our country to other countries if possible, under some reasons, okay? Under some reasons. So this is what saying power of the Parliament, either to annex or to expel. Is it clear? So that is what your Article 2. But there is a significance for this Article 2 with the name called Article 2A. 2A. It is nothing but your Sikkim. Okay, Sikkim. So admission or re-establishment of new states can be seen as a part of your Article 2, and hence Sikkim to be associated with the Union. So the historical significance of Sikkim, Sikkim previously was under Chogyal dynasty. Okay, there because of the trend which was followed by the people in support of India to become the part of Indian Union, their hesitation started when their rights were affected by the Chogyal rulers. Right from the Britishers, it is a treaty between British and Sikkim. Okay, so there the point come. So when that protest started there, plebiscite conducted, and they decided that so-called region where protests were there, the so-called region where the people were intended to become the part of Indian Union, they merged that region, they annexed that region into the Indian Union. That is of okay. But what happened, when it was happened by that time in India, protests are going on for the regional bifurcation of the states based on language or many other manifestations. But all those were kept aside by the then government of the time, and giving a status of a state to the Sikkim really gained that importance, where protests against the central government, regionalism was started in India. Okay, and because of that, center-state relations was also got deteriorated. Okay, so in that context, Sikkim is having a significance. So 35th Constitutional Amendment Act 1973 clearly giving what the status for the Sikkim, later on complete status as a state. It turned as a complete state. Okay, so this I will connect the dot at the time of Article 3. Okay, so this is what the point is. And then comes your Article 3, nothing but power of the Parliament. It is the power and right of the Parliament with a simple majority to reorganize the states. Okay, so reorganization of states, and this is where very important, because as we are preparing for the regional subjects, Article 3 is more important in the context of Andhra and Telangana as well. So Article 3 is saying what it is talking about reorganization of states. Who is having the power? Parliament is having the power. What is that majority required? Simple majority. Simple majority is required. Simple majority is required. I hope I am clear. So according to Article 3, keep a point in your mind. Keep a point in your mind. What exactly do you mean by reorganization? Reorganization means alteration of boundaries. It is also the same alteration of the names of the state, changing the names of the state. It is also alteration of areas, and more importantly, it is also to be called as formation of new states. Formation of new states. Okay, formation of new states in the sense either one state can be bifurcated into n number or vice versa. Even n number of states, 2 or more number of states can also become one state. For the administrative feasibility, this is what exactly the power of the Parliament with a simple majority is talking about. So Parliament by law can form a new state by separation of a territory from any state, or by uniting 2 or more states, or the parts of the states by uniting any territory to a part of any state, either by increasing the area or decreasing the area, changing the boundaries, either by increasing or decreasing, or even changing the names of the state, or formation of a new state, creation of a new state. So this is what the point is talking about. But for examination point of view, you need to understand a small point here. What is that point is clearly intended to say, that is the point which is talking about no bill. See how a bill of reorganization is to be introduced. See, President of India, it is mandatory for the President of India asking the central government, asking the cabinet to introduce the bill in the Parliament. But prior to that, the President should take the consultation, should take the opinion of the state through governor. And here the state resolution is to be passed, and this resolution is nothing but the opinion of the state, which will be submitted to the governor, and governor to president, and president will ask to introduce in your Parliament of India. Okay, so here resolution should be passed by 2/3 majority of the house, and here Parliament should pass with simple majority. Parliament should pass with simple majority. Simple majority is enough. Okay, so now the point here to understand is, President is not at all mandated to bind over the decision given by the state government. I hope I am clear. Okay, so this is just an expression of views with the name called consultation. So President may allow the state to give their opinion by giving a significant time period for passing a resolution, and it is not mandatory again. Okay, so this so-called point, okay, you need to understand when we are talking about this article, there are some clauses like Article 3A to 3E. Okay, 3A to E. So try to understand, there the state includes the union territory, The state does not include union territory. That is where the logic was. So keep a point in your mind when we are talking about reorganization of states, their union territories are not at all going to be the part of this Article 3. Okay. So now it is the power of the parliament to form a new state, okay, and through with simple majority is the point which we need to remember, and this is what the governance part under this. Okay, is it clear? So this is what the point is. And now Article 4. What Article 4 is talking about? Article 4 is talking about two important points which falls under 4A and 4B. Okay, what it is saying, any laws made under Article 2 and 3, any laws made under Article 2 and 3 to provide for the amendment of the first and fourth schedule means automatically first and fourth schedules of Indian Constitution is going to be amended or updated. So what is Schedule 1 of Indian Constitution? It is talking about the names, it is talking about the boundaries, it is talking about the areas of our Indian Union and its territories. Okay, and hence if under Article 3, if there is a reorganization of a state made by the parliament, then automatically the new names, the new boundaries, the new laws, the new areas, everything will be get updated in your Schedule 1. Not only that, Schedule 4 is talking about representation of the state to Rajya Sabha. So the number of members from a state to Rajya Sabha will also change if Article 2 and 3 are going to change. Okay, so automatically your first and fourth schedules of Indian Constitution are going to be amended and updated according to the provision of laws made under Articles 2 and 3. This is the first point to remember. Okay, and the second point to remember here is, whenever there is a law made by the parliament with respect to Article 2 and 3, okay, simple majority is only required. No need of constitutional amendment majority, means 2/3 special majority according to Article 368 is not at all required. So this is what the point of your Article 4. So Article 1, 2, 3, 4 is talking about a union and its territories, and I hope I am clear. So this is what the complete points with respect to these. Okay, so keep some points in your mind as we are preparing for this examination. Prior permission or recommendation of the President of India is necessary for the state creation or remaining bill with respect to the state formations. Means under Article 3, prior recommendation of the President is required. This is the point. No such provision is mandatory under Article 2. For Article 2, President's prior recommendation is not at all required. Only for Article 3, prior recommendation of President is required. This is the first point to remember. The second point to remember, for creation and destruction of the state, the permission of the concerned state is not at all mandatory. Whatever resolution passing saying, let me say the example, at the time of the demand for Telangana to form as a separate state in Andhra Pradesh, combined Andhra Pradesh, the state legislature passed a resolution giving its opinion to not to bifurcate the state, not to divide the state, but that was kept aside by the center, right? That shows clearly it is not mandatory to follow the resolution passed by the states. So this is the point which you need to understand. So this is the second point to understand. Coming to the third point here, whenever there is updation. Okay, updation with respect to Article 2 and 3, obviously your 7th schedule, which is talking about union list, state list and concurrent list along with the residual list, that powers means your union power, state power, concurrent power, residual powers mentioned under 7th schedule of Indian Constitution will automatically get updated, will change. That is the third point here we are talking about. And then the Constitution, 40th Amendment Act 1976, 40th Constitutional Amendment Act 1976. According to this, it substituted a new article got introduced, 297, Article 297. So as to vest in Union of India all lands, the minerals and other things with respect to the value underlying to the ocean with the territorial waters or the continental zones, exclusive economic zones, everything under your central government power. It is the power of the central government to look into the issues of dividing the powers, dividing the resources, dividing the things with respect to mines, mines, natural resources, ocean bodies, territorial water bodies, everything. Final decision rests with the center. You cannot go and knock the doors of the court. This is what the article and your 40th Amendment, Constitutional Amendment Act 1976 is talking about. So these are the important points you need to remember with respect to your articles 1, 2, 3, 4. Okay, and now as citizenship was not exclusively mentioned as a part of our syllabus, we are not going in deep about the articles. You can keep those articles from 5 to 11 kept aside. Keep one article in your mind is with respect to your Article 11. What Article 11 is saying with respect to citizenship and its amendment, provisions, laws, whatever with respect to the citizenship, the final power rests with the Parliament of India. So parliamentary laws are final with simple majority. That's it. But as there is a context of current affair with respect to CAA, okay, Citizenship Amendment Act, or with respect to NRC, that as a current affair, in the current affairs session, by the end of the module, you will get that a clarity. Okay, and now in our next coming session, we are going to discuss about fundamental rights. Okay, and that fundamental rights is all about your core important concerns which is revolving around your syllabus. So understanding fundamental rights will make you to gain the confidence not only with respect to polity but also with respect to governance as well as social justice as well. Okay, so in our next class, we are going to discuss about what? Fundamental rights. Until then, this is the class with respect to the chapters. I mean, the first unit, 50% of the chapters got completed. In the first unit, the next 50% we are going to complete in the next session, next upcoming session. So this is all for this session. This is all for the day as well. So have a good day. This is Shankar.